Good evening and welcome, everyone. Next slide. Hello, I'm Chris Raffanan, Manager of Investments for Patelco Financial Solutions, and welcome to part one of our estate planning webinar series. Next slide. First things first, I want to show this important disclosure of what we sometimes call the not may. In short, investment products are not FDIC insured or NCUA insured. They're not guaranteed by the credit union and may lose value. Before we get started, let's go over a few housekeeping items. All participants will be in listen-only mode. Today's presentation will last about 60 minutes. We encourage you to type in your questions in the Q&A section as you think of them at any time during the presentation. Please do not use chat. After the presentation, we will begin the Q&A session. October is National Estate Planning Awareness Month. Tonight's presentation is all about the basics. Our guest speaker will cover living trusts, wills, advanced healthcare directives, and powers of attorney, among other things. In 2 weeks, on Wednesday, October 23rd at 5:30 p.m., we will have part two of our estate planning series, which is a deep dive on having the honest conversation with your loved ones about your wishes, identifying caretakers for loved ones, creating and storing important documents, selecting decision makers, setting up account access, and we will show you how to register for part two at the end of tonight's webinar. Also, at the end of the webinar, we will show you our digital solution for estate planning for those do-it-yourself people, as well as an investment promotion where you can invest $25,000 or more and receive a $100 Amazon e-card. For tonight's presentation, our speaker, attorney Ed Cainglit, will present for about 40 minutes, after which we will begin the Q&A session. We do apologize ahead of time because with a webinar this large, we won't be able to answer all the questions. But rest assured, at the end of the presentation, we will show you how to reach out to Ed and his team at Oak Crest Law to request an appointment. Now, allow me to read Ed Cainglit's bio. Attorney Edward Cainglit graduated from the University of Southern California and Whittier Law School. The cornerstone of Ed's practice is to help clients leverage the value of estate planning to accomplish their financial and their personal and legacy objectives. Edward achieves this by merging his teaching experience with trust and estate law. Ed and his team offer a client-centered approach to legacy planning by educating and counseling clients throughout the estate planning process. At this time, I'd like to turn it over to Ed to start the presentation.
Thanks, Chris, and thank you for that wonderful introduction. Good evening to all the Patelco members in attendance. I am so honored, and I'm actually excited. I'm taking a look at the individuals who are checking in, and it's a very exciting time. First, I wanted to say that I am so happy to be back. I've had the pleasure, honor, and wonderful opportunity to present the estate planning presentation here at Patelco for several years. And I've also had the honor of representing many of the wonderful Patelco members. So I wanted to say that this is, number one, an educational presentation. So I encourage people to listen. I don't necessarily want you to get bogged down with notes. This is being recorded. You will get a copy, a digital copy of this presentation, number one. But number two, I'm going to encourage you to actually jot down your questions. One of the things that's really important in this educational presentation is that I try to get a lot of your questions answered. And just like Chris said, because there are so many of you, and I'm so excited that you've all attended this party. We will give everyone an opportunity to send us your questions through email. We'll have a very convenient QR code so that you can contact our office. So that's very important to me. What we've done is it's exciting. It's a twist on my regular presentation. It's still the same presentation in terms of context. However, it's framed in a way where we're focusing on 5 very costly mistakes that I see. And I've been practicing long enough. I've been practicing for over 15 years. And I want to educate the community with respect to 5 very costly mistakes that people do when they consider their estate planning. So with that said, I want to start with the number one reason in this costly mistake succession. Number one is failing to plan. And a lot of people say if you fail to plan, then you plan to fail. The statistics show, for example, that over 70% of the American public does not have an adequate estate plan. Now, this used to be worse pre-pandemic. It used to be 80%. And I suppose the pandemic scared everyone with respect to this 10% shift. But a majority of Americans do not do estate planning. And that is the reason why it is so high. And this is just a recent study from 2022. Although 40% have a will, 17% have a trust. Most people don't have all the pieces in proper place and alignment to constitute an adequate plan. Most cases will have to go to probate, which I'll do a deep dive. Here in California, if you do not have an estate plan, or if you have, for example, a legal document called a will, it's essentially a guaranteed court hearing, and we call that probate, which can take a very, very long time. And it's a while for the family before they receive final closure because it is a purely public process. Who needs an estate plan? This is important because I think when people say estate planning, or even just using the word estate, they necessarily think that they need millions or billions of dollars, and that's really not the case. If you have children, if you have minor children, or perhaps you are the guardian of your grandchildren, you need an estate plan. Anyone that has real property. Now, real property, there is a threshold in California, but essentially the situation in California is that real property a lot of the times is your major asset, right? And so if you have real property, that's a primary reason why you'll need an estate plan, particularly a trust. Anyone that has more than 180,000 in assets, specifically it's 184,500. So let's say you don't have a home, you're renting, and you have other assets. You have cash in the bank, you have retirement accounts, you have life insurance, death benefit. You add all of that up, and if it's greater than 184,500, you need an estate plan. Anyone who wants their assets to be transferred to a specific loved one. What does that mean? I'll go over specific situations. For example, Marilyn Monroe was actually charitable. She wanted to give 75% of her estate to charity. The court will not, if you don't leave instructions, if you don't specify, if you don't designate, the court will not know to give to your specific beneficiaries. Let's say you have 2 children, and let's say one child is special needs or needs special attention. For example, they cannot have gainful employment because of a handicap, for example. And let's say you wanted to go so far as to give 80% to that child and 20% to the other child. You need to be specific about that because the courthouse will not know how to do that. I have a wonderful video about blended families. And it's the reality that when I meet with clients, it's a blended family situation, like Brady Bunch, for example. one of the things that I've noticed is that people oversimplify their estate planning in a blended family situation. So if there is a specific instruction, if you want to give to a friend, if you want to give to a particular loved one that is not part of the state's plan, you need to set up your own estate plan. So what happens if you die without an estate plan? So this is the case where about 35% of people, so it's 70% don't have an adequate estate plan. Half of that, which is about 35% of people, don't have anything. They don't have a will, they don't have a trust. So some property passes automatically to a joint owner. So for example, if you own the home with your spouse, or if you own the home with your sister, or a bank account with a friend, right? It'll pass automatically to the other. Or if there is a designated beneficiary. So a lot of assets, a lot of financial assets like retirement plans or life insurance policies, you must necessarily designate a beneficiary when you set up these accounts. So these assets will automatically pass to either a joint owner or to an individual that survives you that is your beneficiary. However, all other property generally passes according to state intestacy law. So one of my favorite cases that I use when I present basic estate planning is the situation with James Dean. James Dean was very young. He was only 24 years old when he passed away, and he was already famous. By the time he passed away, he was not married. He didn't have any kids, and his mother had predeceased him. So because he fell in this category where he did not designate or he did not set up an estate plan, the state of California made these decisions for him. And specifically in his case, the state gave everything to his father. Now, for some people, choosing your father might be the correct answer, but you should all know that James Dean's father abandoned James Dean and his family when he was young. So there's an argument to be made that the state got this wrong. But in reality, the state doesn't care because the state is dealing with 35% of people and another 35% of other people that use a will, which I'll talk about next. For a whopping 70% of people, the state is making these types of decisions, administering these estates, and they're just tired. For example, they don't care. They've already decided, and they're going to give according to these intestacy laws. So what's the moral of the story here? The moral of the story is, if you want to be specific, if you want to choose someone, and it's not just even Steven, divided evenly, right? You're in a blended family situation, you better set up an estate plan and make your own decisions. And I think you're the best person to make your decisions because guess what? You worked for it, you dreamt, you created it, you hustled to acquire this asset. So why not set up a plan that comports, that reflects with your wishes and your dreams? So wills and probate. So now we have this other category where you don't have anything like James Dean, right? Versus you have a will, right? So what is the difference and what happens? So most wills must be probated. What does that mean? Most wills must be probated. So if you have assets greater than 184,000 and you use a will, or let's say you have a home and you use a will, that will necessarily will go to the courthouse and it will be what we say probated in the Superior Court. A will is filed with the court. The person designated in the will, called an executor or an administrator, will collect, will pay debts, essentially take care of your business, and ultimately will be responsible for distributing your property to whoever is designated in your will. Typically, this can be 1 to 2 years in all of California. Again, if there are not a lot of assets, you don't have to go through formal probate. It can take several months. We just need a death certificate, for example. But if you do fall in this category, like a lot of you, you have a home, you have other assets, that are about 184,500, it takes a very, very long time. It's expensive and it is purely public, right? So I'm going to be going over a lot of things. If there's anything that I want you to remember is you don't want to end up in this court because it's very expensive. It takes a long time and everyone will know your business. It's very public. So like I said, it's about 5 to 10% of the value. So let's just take one home subject to a mortgage with only 400,000 equity. In probate, they will not take 10% of the equity. They'll take 10% of the fair market value, which is $1 million. And that's why it's very expensive. It also takes a very long time, 1 to 2 years. However, in larger counties like Los Angeles County, where it is literally a zoo, big counties, it's not uncommon to wait 3, 4, or 5 years. And we're talking about straightforward administrations. If there is a fight between the two siblings, which happens quite often in the court setting because it's a perfect boxing match of a situation, it can take much, much, much longer than that, right? So number one, it's about 5 to 10%. Easy example is a home fair market value of $1 million, even though there is a mortgage subject to it, even though it only has minimal or half equity, they will take 5 to 10% of the fair market value. 1 to 2 years. If you're in a larger county, it can take 3 to 5 years. And last but not least, it is public. So everyone will know your assets. Everyone will know who's inheriting. So for example, if you have a very young child who's 18 years old, they will inherit and they are perfect to go after. Because when you think about it, if you wanted to scam someone, you're wanting to scam someone whose parent died, who's barely 18 years old, and who is inheriting a home and some financial assets. So let's talk about avoiding probate, right? And some of these are temporary. And then there's the gold standard at the end, which is using trust. So like I said previously, if you own property jointly with what we call rights of survivorship. So we call this joint tenancy with right of survivorship. Very common for a married couple. I see it sometimes with siblings. I see it sometimes with very close relatives. And what this essentially means, if you own it joint tenants with right of survivorship, is if one passes, it automatically goes to the survivor. So again, that's appropriate if you're married. Areas or instances where it's not appropriate is, for example, you have two sisters, joint tenants with right of survivorship, but they have their own families. You would expect that one sister would like it to go to her family, right? And so that could be unfair. So be careful. You will avoid probate, but it will result in an unfair situation. So these are some of the things where people overlook, and you want to be very, very careful, very, very careful. Complete beneficiary designation forms for property such as retirement accounts, life insurance. I always recommend to review these ever so often because I inherit cases where they've listed a beneficiary who is older, for example. So a young individual will list their parents, right? When the policy is taken out when they're younger, like 20 or 30, statistically, a parent will pass away before their child, but they'll never bother to go back and see who the beneficiary is, right? Then they'll pass away. So we have a situation where everyone has passed, including the beneficiary. So be very careful. So long as your beneficiary outlives you, then you are good. But again, you want to make sure you have a primary beneficiary, make sure you want to have a secondary or contingent beneficiary. This next one is very important in the coming months leading up to the end of 2025. Make lifetime gifts. We have this thing called an estate tax, which is a tax that the federal government will assess when you pass away. And I joke to my older clients that 2024 and 2025 is a good time to pass away because the government believes that you will be taxed only if you have more than 13 or so million dollars. So rest assured, for those of you who are listening, and there are several hundred of you listening to me, thank you for your attendance. that if you have less than 13 million and you happen to pass away either this year or next year, there is no estate tax. But, and this is a big one, if you survive and you make it into 2026, that 13 million goes down to less than half, 6 million. This is a highly contested tax. A lot of the politicians use it to get elected. So we'll probably see some chatter. We'll probably see some promises as the landscape changes, like it always does. But for those individuals, for example, that are 98 years old, right, and you have, let's say, $15 million, it is a very exciting time to take advantage of these lifetime gifts, right? And so essentially, the challenge is for you to gift out that money to your loved ones, to your grandkids, to your children, to other people, so that by the time you pass away, right, and anything after 2026 goes down to 6 million. A very sophisticated topic. I don't want to make light of that. It's just gift out gifts. Make sure you take advantage of our assessment call, right? And so we can guide you through that. And finally, I believe the gold standard, which is where I'm leading you to, is using trusts, right? So recap, nothing, James Dean, you will go to probate, state of California will decide. And good luck if you have specific instructions. Number two, if you have a will, it's okay if you don't have any substantial assets. My good friend jokes that if you only have one cat and a tape recorder or an 8-track, then you can have a will. It will not go to probate court. But if you use a will, like Marilyn Monroe did, for example, it will go to probate if you have financial assets, substantial financial assets. And the final one is the trust. And let's talk about that. I wanted to go over, this is a loaded slide. So if you guys are listening to me on your phones, I want you to get your phone. Let's make sure that I see myself. Get your phone, and you might need to turn your camera this way and expand, because this is a loaded slide and it's very important. So bear with me. I wanted to compare and contrast, right? I'm here tonight again in the spirit of education, and I'm not going to expect almost 500 of you to be my clients, but I want to educate you on what is out there, what is reasonable, and what you can expect, right? So these are your options. There's 4 categories. Some are tricky, right? And some are reasonable. So this first one is the no plan, right? You leave it up to the state of California through intestacy. It's free, right? Because you're not setting anything up, but it's going to go through probate. So I don't necessarily recommend that. Now, again, if you don't have substantial assets, you don't necessarily need to do something sophisticated. And for example, if you want the default rules, right, you want it to go evenly to your kids or to your surviving spouse, then that's fine. Now, this next one is a very good plan for some people in the category of simplicity. So no attorney, it's a digital platform. Now, I'm aging myself. I'm almost 50 years old. The digital platform back in the day was something called LegalZoom. And I'll be honest, I like LegalZoom because it did all my marketing. It did all my marketing because it was very, very popular. I know that Patelco has a digital platform that they'll explain at the end. It's forms-driven, limited attorney, sometimes no attorney. And you sort of have to be very resourceful. You have to listen, pay attention to the question. And it's much, much more affordable. I recommend this if you don't have anything specific. You don't have a special needs child. You're not in a blended family situation. You don't have sophisticated assets, for example. And I know these rates are very good. So I like that option because, you know, we need more options. Like I said, 70% of people get it wrong, right? So this option is for you. Now, when it comes to attorney assistance, there's 2 categories. Attorneys with multiple services. What does that mean, multiple services? It'll be like a general practicing physician, right? It's probably okay to go for a stomach ache. It's probably okay to go for an ear infection. But if you have something specific, the services might be limited. The fees in this range, $500 to $1,500. All right. And then finally, you go to the most sophisticated category. And I don't want to say sophisticated like, you know, it's the best, but you're going there because you need guidance. You're going there because you want someone to guide you. You're going there because you're going to say, here's my situation. What should I do? Right. So you're looking for someone to guide you through the process. Focus in estate planning. They're not doing anything else. They're not doing family law. They also don't have any other businesses. They're not a secret realtor. They're not in it to invest your money. There are a lot of attorneys believe it that are dual degree, right? They will pull you in to say that they'll draft a trust, but they'll want to refinance your home because that's how they make money, or they'll want to roll over your IRA accounts. I'm just a plain old attorney. This is all I do. This is all I've done over the last 16 years, so I know it well. We focus on planning, on administration, and we do some probates by courtesy, but the fact that I'm here encouraging you not to go through probate is I'm hoping that all of you don't go through probate and set up your own estate plan. So it's personalized service. And I'll be very honest, at this rate, you're looking at 5,000 and higher. But here's the wonderful thing about this webinar. Patelco has negotiated a wonderful rate for its members. And again, I've been so honored to be the presenter. Over several years, I've represented hundreds of Patelco clients. So I've been there. I have the track record. We do follow up with all of our clients. And so we are happy to continue this special rate. I will go over it at the end, so you'll have to stay tuned. All right. So number 2, incomplete plan. What does that mean? You're missing key documents or you don't have the right documents. So I've used the example of Marilyn Monroe. She was, so number 1, she used a will, right? And so a lot of you are, I know that there was one question, a question that was submitted previously is, should I use a will or should I use a trust? Marilyn Monroe used a will, right? I want to humanize the problem, right? I'm using very famous people from Michael Jackson to James Dean to Marilyn Monroe, people who are famous, people who have access. They have business managers, they have accountants, they have multiple attorneys, and yet they still get it wrong, right? And so if you have assets, if you have a home, if you have financial assets, you want to make sure you're going and getting advice to guide you through the right pathway, right? So a lot of estate plans are missing pour over wills. I'll go over what the difference is a regular will and a pour over will. And so you want to make sure that for you and your circumstances with your assets and your family, you have the right documents in place. And I would say one of the things that I see in estate plans is that there is no provision if the individual becomes incapacitated. And what does that mean? A lot of people think, again, it's in the category of oversimplifying the situation. So they say, you know, Ed, I'm a simple person. My family's simple. My assets are simple. I just want a simple estate plan, right? And so I'll assess and I'll read what they've done already. And one of the things that I see consistently is an estate plan that does not account for incapacity, right? So it's now 2024. The medicine is better than it was 20 years ago, 40 years ago, and 60 years ago. People are living longer. Allegedly, people are going to be living past 120 years old, right? And it could be that your heart is great. You've got a wonderful, warm heart, but your mind is not there anymore. You are mentally incapacitated. You're mentally incapacitated. There's cognitive decline, right? So you want to make sure that you have an estate plan that doesn't just cover you when you pass away, but also protects you when you're incapacitated, because your estate plan should not benefit anyone else except you, so long as you're still alive. So even though you're 98 years old and you're going to live for another 22 years to 120, that estate plan, that trust, those provisions need to be very clear that you are still the beneficiary, right? So that's number one. It can strike anyone at any time. Statistically, you are incapacitated up to 7 years before you actually pass away. You have famous people like Britney Spears, for example, that don't have the appropriate documentation to protect them. And so they end up in the courthouse. The probate version of this is called a conservatorship, and it's very expensive and it's highly contested because one of the things that the court is doing is removing your right to decision making, your right to who you associate with, your right to contracts, business, executive decisions, and they are putting that with someone else. In the Britney Spears case, they put that with her father, which there's an argument that was the wrong person. Now, how did that happen? Number one, because she never made these critical decisions, and she allowed the courthouse to assume. And because a father is your parents, because there is close familial connection, the court can make these assumptions when they don't have other guidance, right? So if she had a plan that said, my father should not be my conservator, it should be my business manager, right? Then that would be something that would be in place to rebut the presumption that her family, like her father, should be making critical decisions for her. So again, the theme is you guys need to take control. You guys need to make a decision because the best person to make decisions about your personal well-being and safety is you. So there are up to 4 documents. And again, I'll go over this in more detail on another slide, but the durable power of attorney, this is a document that says if I become mentally incapacitated, I'm allowing this person to make decisions for me. HIPAA waiver and the Advanced Healthcare Directive, these are documents for your personal well-being. Assuming you lose capacity, you need someone to make medical decisions for you. A HIPAA waiver allows a third party to view otherwise private medical information so that they can have an informed decision with respect to should you have surgery A or surgery B. They'll be able to review your blood tests, to review your X-ray examination so that they can make a decision. The directive is actually the document where you list this person can decide. And it does 3 things. It is a healthcare power of attorney. So you're choosing someone to make healthcare decisions for you. In the event that you are passing away and the condition is irreversible and incurable, you're deciding if you want heroic measures, artificial measures to stay alive. Or in the alternative, if you want to pass away naturally, so long as it is irreversible and incurable. And the final thing that it does is it goes over the final disposition of your remains, donation, and you can also put in there, for example, if you prefer cremation and exactly what would you like to do for your memorial instructions. And then finally, this is the document that Britney Spears did not have as a nomination of conservator. In the event that we have to go to court, because the court is the only viable option, you are putting together a legal document that says, this is who my conservator should be. All right. So I'm very proud of this video. This is my video about the Brady Bunch situation. And essentially, I know there's a lot of you that are in a blended family situation, meaning your child is not the child of your partners. And I want you to be very careful of oversimplifying the situation, right? So for example, in this case, you have the husband on the bottom, and if he passes away, right, he has 3 sons from a prior relationship. We cannot assume that everything should go to his wife. And the reason why we can't assume that is the wife is not the biological parents of his 3 children. Again, be very wary and be very careful of oversimplifying in a blended family situation. So one of the things that I recommend is making sure that when you pass away, your children are safe and protected, because it's not only uncomfortable, but it is very strange for your children to have to wait, for example, for their stepmother to pass before they inherit. Not to mention, let's just say your spouse never really liked your kids. right? And that could happen. I mean, if you look at the Brady Bunch situation, no one really liked Marcia because she was so annoying, for example. And if you oversimplify it, for example, it could be that your spouse can actually disinherit your children. So there will be a slide about collaboration where I will say that estate planning is actually part of financial planning. And again, I'm so honored to be partnering with Patelco and giving me this opportunity to educate the community to really challenge the public about how proper estate planning should be. It should be done collectively, especially with a financial advisor. So an example like this, I will say, if you pass first, we should go over your assets. And I think certain assets like life insurance will be wonderful assets to give to your children so that it's immediate because you passed away and your spouse survived you. And that way it wouldn't be strange, for example, for your kids to wait for your spouse, their stepmother, for example, or stepfather in the opposite situation for them to inherit. Just a thought. And again, it's not for all of you, but it's for some of you to give you an idea of what is out there. Now, here's a video of a trust, right? So number one, the confusing thing about a trust, hopefully I will not make it so confusing, is that when you create it, you are three people. You are the owner, you're also the beneficiary, and you're also the trustee, or what I call the manager. All right. So you're all three of these people. No one is the beneficiary unless you pass away. Now, in this trust, you've already made critical decisions about the future. So, for example, if you get sick and you lose capacity, you've already decided who the manager will be. It won't be you because you're incapacitated. You're in the hospital, for example. And then ultimately, if you pass away, whenever that is, you've already designated who the future beneficiaries are. So to recap, you will always be the beneficiary unless you pass away. You will no longer be the manager if you lose capacity, and you've already decided who that manager is. You are making that decision. It could be your spouse, it could be your oldest child who happens to be an accountant, or it could be a third party, right? Sometimes not choosing your family is the right decision. So it could be an accountant. In California, we have individuals called private fiduciaries. And those are wonderful options because they're neutral, they're licensed and bonded, and they're very familiar with this process. Let's go to the next slide. Right? So a compare and contrast of wills versus trusts, right? A will is not sophisticated, so it's less time, but you all know through my video that it costs a lot, up to 10%, right? So you must go to the probate court, right? And so I'm suggesting to all of you, if you have assets, not to use a will because of probate. Now, on the other hand, the trust, right? It's more sophisticated. You're going to have to pay more, right? I did say it's on average $5,000, but don't forget, there is a very special Patelco negotiated rate. Stay till the end, right? If it's done properly, you completely avoid probate, so no 10%. And if it's drafted correctly, you have incapacity provision, so you do not have to go through a conservatorship, and you can include protection for your family, for example. So for example, if you don't like who your son is married, this is a really popular one in my office, and mothers are always concerned about this. So let's say the children are older, the children have kids and they're married, but mom comes to me and says, you know what, I love my son, but I don't like who he's married to. And she's cringing about the future when she's no longer here. And the son's going to inherit the wealth. And then, quite possibly, the wife or the spouse of the son is going to take it away. So there are things you can do. Yes, it's advanced, where we can actually protect the inheritance for that son so that it does not go to the spouse. So if the son prematurely passes, it can go to the children, my client's grandchildren, or God forbid there's a divorce, for example. We can set up that trust in a way so that it will not go to your son's spouse, what I call the evil daughter-in-law or the evil son-in-law. All right, so let's go over what a basic estate planning, the basic estate planning documents, right? And again, there's some room here on the bottom. I'll go over some extras that we include in our basic plan. So I've mostly been talking about the living trust, right? This is the trust that avoids probate. We will also draft a certificate of trust. This is an important document because your trust has a lot of sensitive information in there. It says who your kids are, it says who's inheriting, and it references your other assets. Third parties like banks, financial institutions will want a copy of that trust because we will have to update the title to those assets. Give me a second. And so what this certificate is, it's a shortened version of your trust. It could be 1 to 3 pages. And this is actually the document that you would give to a third party so that you wouldn't have to give them the large trust with a lot of sensitive information. So it doubles up as a condensed, summarized version of your trust. The third document is a pour over will. So you should cringe a little bit because wills go through probate, but this is a special companion will to a trust, and it serves for one function, which is you've got a trust, majority of your assets are in the trust, but you forgot to put one thing in your trust. So perfect example is you have 3 houses. 2 of them are in the name of the trust, and the way that is done is the deed is registered and recorded in the name of the trust. But that third real property, you forgot to put in your trust and you passed away. So those 2 houses, homes, will avoid probate because it's in the trust. That third one, we will use this pour over will. Yes, we'll have to go to court. And what the court will do is they will approve it so that it will be transferred thereafter to the trust. So it pours it into the trust. So that's a good thing about it. If you just update your assets and update and retitle everything so that everything is in the name of the trust, you will not have to use this pour over will. I've been in practice for a long time, and I'm going to knock on wood. This is a table. We have never had to use a pour over will in my practice, and I hope that continues. Advanced Healthcare Directive, HIPAA waiver. These are the 2 documents I referenced earlier. They allow you to choose people to make medical decisions, and they allow third party to have access to private medical information. Durable power of attorney is a document that you allow someone to make financial decisions if you become incapacitated. For those of you that have minor children, you're also going to nominate your guardians, and you're going to nominate your conservators in the event that we need to go to court. Personal property memorandum. So this is a document where if you want to give the Picasso painting and the Fabergé egg to a particular person, individual, child, you'll be listing that in this memorandum. You can give a car, you can give your golf clubs, you can give your tools, you can give your special watch. Funding instructions. This is a very important document that itemizes each and every one of your assets and tells you exactly what to do, because you have to fund your trust. And I'll go into that in a separate slide. Assignment of personal property, a very simple document that you sign that says all my personal property now belongs to my trust. So these are the basics, right? So number 3, an unfunded trust. So this is a picture with 1,000 words. You are not going to jump into a pool if it does not have water. Why would you have a trust if nothing is in it? And I will tell you that this is happening all over the place. This is particularly happening with a lot of the digital platforms because there is not continuity of the services that are needed. And again, I'm using very famous people. When Michael Jackson passed away over 10 years ago, he actually passed away with an unfunded estate plan. Nothing was in his trust. They had to go to court. They had to use a pour over will. So it's so important to fund your trust. 3 examples of assets so that you can understand. You have a bank account at Patelco, you have a home, and then you have an insurance policy. So your Patelco account, you will bring your certification of trust. They will update your signature cards so that you are the trustee of your trust. You're done. Number 2, your home. You will have to prepare a deed, transferring it from your name to your trust. then you have to record it with the county that the home is in. And once it's recorded, you're done. Number three, a life insurance policy. If you are an individual, if you're single, then your primary beneficiary should be your trust. However, if you're married and you like your spouse, I'll say that again. If you're married and you like your spouse, then you list your spouse as the primary beneficiary and then the trust as a secondary beneficiary. If you're married and you're not sure if you like your spouse, then you will list your trust as the primary beneficiary. This is perfect, for example, for blended families where if you pass, you are going to let it go to the trust so that it can be administered in the trust. And your kids, who are not the children of your spouse, will receive in that manner. It's nice and clean. It's very transparent. And we're just trying to be fair, right? And so these are examples of funding your trust. Now, let me pause here because this is another diagram that I think separates me from a lot of my colleagues who practice in estate planning. And here's my point. The estate plan is part of your financial plan. And that's one of the reasons why I work so well with financial advisors. And again, Chris here at Patelco will go over what they do at Patelco with respect to their services when it comes to financial services. But I believe that both the financial advisor and the trust attorney need to work together for the benefit of the member. And it's literally a collaborated or an ensemble approach, right? Because not only are you working with me to give you the direction of what will happen to your assets, but you also need to work with the financial advisors to make sure that those assets are appropriate. Are they going to be sufficient for you through retirement? Are they going to be sufficient for you if, for example, if you got young children and if you prematurely pass away, right? And so I do not have any legal licenses to practice financial advising, and I will defer to your financial advisor. So if you don't have one, I'll gently request that you go over what's the difference between this insurance and that insurance. Is this retirement plan appropriate for your situation? And I believe that is one of the reasons why people who work with me always have a funded plan, because it's more collaborated. You've got more people on your team to make sure that you are protected and safe. Number four, fail to update outdated plan. So, I see people who have created estate plans in the 80s and the 90s, and the tax laws were different. For example, just 20 years ago, the estate tax was 600,000, right? I did say that currently it's about 12, 13 million, but like 20 years ago, if you had more than 600,000, anything after that was 55%. And so there were estate plans created a long time ago that were appropriate for that time because the tax landscape was so different. The problem is if you don't update your estate plan, and then you pass away with an outdated plan, we're sort of stuck. I've actually had to go to court to fix old trusts and beg the judges to say, Your Honor, this was done in 1984. This does not reflect, the current status of affairs. So we are respectfully requesting for you to take this provision out because it makes no sense. So long as all the beneficiaries approve, sometimes I'm able to, but we have to go to court. It's expensive. It's tens of thousands of dollars to do that. So I recommend you look at your estate plan every year and you see, hey, do I still like that person? Are they still my friend? Do I like that charity? Are my kids behaving, for example? One of my favorite clients will call me after Thanksgiving and disinherit his one only daughter. And then by Christmas, a month later, they'll make up and then he'll call me and say, put her back in. He's been the best client for me over the years because he has this type of relationship with his daughter. I'm not saying that you need to do that, but you need to know your decisions. Any changes? Is there a birth? Is there a death? Is there a divorce? Make sure you update your estate plan. And finally, the failure to communicate. The clueless family, you're not, it's someone passes away and they don't know what the burial instructions are. They don't know whether or not the client wants heroic measures. This is a big thing, right? Unknown desires for distribution, final remains, trustee duties, failure to coordinate a professional team. This is quite obvious. And I think the way I've presented this is in the reverse, which is, when you have an estate plan, you need to nurture it. It's called a living trust because it needs to live and grow with you, not just in 2024, but in 2036, if you are around. You still have to nurture it and make sure that it is consistent to where you are at. So, one of the hardest things, and I think this is the reason why 70% of people don't plan, is they don't want to think about dying, right? It's a hard topic. It's a taboo topic. When you look at a hearse, for example, there's no luggage racks. There's no trailer. There's no hitch. You can't take it with you. And the last thing that you want to do is be a burden on your family, right? And if it goes through probate, if the instructions are not there, your family will be severely burdened. And really what the challenge is to live with the peace of mind, to equip that next generation so that it doesn't have to start all over again and go through probate, and just, support that next generation. So I did go over the basic documents. Here are some things that we include. So we actually go so far as to record that deed. Believe it or not, some platforms like the digital platform, you'll have to do it yourself. And a lot of people's assets primarily are the real property. So it includes one, we'll file it with your county recorder, make sure that the taxes are the same in the assessor's office. We do give digital and actual hard copies. Over the years, I've had many different binders. Our binder is so darn attractive. I'm really proud of it. And it's in an attractive binder. We're not, you're not just going to get documents in a manila folder, for example, like some attorneys do. Two things that are very special, a lot of my colleagues do not do this. We'll also give you an electronic successor trustee manual. Probably one of my top 10 questions is, great, I have this estate plan. Well, what does the trustee, my daughter, need to know? Well, I have a wonderful, comprehensive successor trustee manual. It's like 108 pages. It's very comprehensive, and it literally gives your successor trustee the what, the who, the how, the when. And finally, probably what distinguishes me the most is a letter of wishes. So I talked about the failure to communicate in a prior slide, right? One of the things that I encourage my clients to do is put out your wishes in a letter form. So this is not a legal document. This is a document where my client will write out what they did and explain to their kids. And always, when I do an administration, meaning my client has passed, the children, the loved ones will take this letter and they will tell me, Ed and team at Oak Crest, we love what you did with the estate plan, but we want to particularly thank you for this letter of wishes. It's a letter that mom writes in her own hand in blue ink, and it's the best gift you can give to your kids to tie everything together. All right. So I know that you are sticking around, sitting at the corner of your seat. And again, thank you for staying on. Really, really humbled for this opportunity. You guys are all still there listening to me. And so this is a very, very special rate that has been negotiated by Patelco. I've been here for several years, and again, have been able to assist hundreds of you. And this is what it is. Our normal rate, and it's a true statement, is almost $5,000. It's 40% off. 40% off. It's $2,950. $2,950. I don't want to say this, but it is a steal. And I encourage you to take advantage of this opportunity. So we're going to get to the questions, but I went over a lot, and you're probably thinking, where do I fall? Which category? Should I do the digital platform? Should I hire a Sherpa and use a guide like Oak Crest Law Group? I kind of like Ed. He seems like a decent guy. You might fall into that category, and here's what I recommend. Schedule your complimentary assessment. We put complimentary in bold and caps because that means free, right? And in that assessment, we will tell you, hey, I think you are appropriate for the digital platform. Or, you know, because of the sophistication of your assets, because of that one instruction for your son, I think you should go the method where an attorney is going to guide you through the process, right? So that is free. That is the code. Some people are unfamiliar with the code. So there's the email, trust with an S at oakcrestlaw.com. And then we still have an old-fashioned 800 number, which I love. 800-631-1881. 800-631-1881. All right. Thank you, Chris, for this opportunity. I think I've hogged the mic long enough. My voice has gone out like 3 times. So I'm going to transition over to you for the questions, and then we can close.
Thank you, Ed. Such valuable information. We do have a little time left for a handful of questions. We do want to apologize in advance. We can't get to everyone's question, but certainly we have them recorded there in the Q&A. First question, Ed. I don't have any family members that I trust. Who should I appoint to make financial decisions if I become sick?
Yeah, I think I hinted that earlier. Sometimes either you don't have family members or your family members are not the right people. And so in California, we do have a wonderful professional called a private fiduciary. They're licensed with the state of California. They're bonded. And this is what they do all day long. And so they serve as successor trustees. They serve as agents in power of attorneys, and they also serve as administrators in will. So that's probably the most affordable, reasonable option. From there, you can also elect your accountant. Your accountant is licensed to serve in that role. It'll probably be a little bit more expensive, but still quality. And then some institutions will serve as trustee, but I would say that's the most costly option. A lot of the institutions will have minimums like 10 million, for example. But yeah, 3 options: private fiduciary, accountants, financial institutions. You can also throw in attorneys. Attorneys will do that. But again, those are on the more pricier side. Highly recommend looking into private fiduciaries.
Thanks, Ed. Just in the interest of time, since it's at the bottom of the hour, we want to be respectful. So we'll go ahead and move on. Again, you can email your questions and we'll get to them. So next slide, Ed. As Ed mentioned throughout the presentation, most people need advice when investing. We have 10 financial advisors available to help you make those decisions. They can help you with tax-free income, retirement planning, retirement income, 401k and IRA rollovers, financial planning, life insurance, long-term care, and wealth transfer. They're available to meet with you in person, over the phone, or via Zoom. Our financial advisors have encrypted version of Zoom for added protection. We'll drop a link in the chat to help you locate a financial advisor assigned to your branch to set up an appointment for no cost, no obligation advice. Or contact me directly either by phone or email, and we can get you to the financial advisor in your area. If you do contact me directly, please let me know what branch is most convenient for you. Next slide. At the start of the webinar, we talked about a digital solution for do-it-yourselfers. If that interests you, here's the information. We'll also drop the link in the chat to find that on the page of patelco.org. Next slide. Now let's talk about the promotion. Today and through the end of the year, you can receive a $100 Amazon e-card for investing $25,000 or more with Patelco Financial Solutions, a maximum of $100 reward per client per calendar year. Next slide. Here's how you can register for Estate Planning Part 2, having an honest conversation with loved ones about your wishes. If you have your phone handy, take a photo of the QR code. And here are the items that will be discussed. Next slide. Lastly, on behalf of Ed, myself, and the entire Patelco team, we want to thank you for attending tonight's webinar. Please check our website and join us for future webinars. And remember, wherever you are on your financial journey, Patelco is here for you. Thank you and good night.
Hey, thanks for watching. Want more financial advice? Make sure you watch the next video here. And you want to hit that subscribe button here.